Ms Legalista here. Welcome to the video. I'm going to be talking about the recent opinion that came down regarding the grants that were being offered to Black women business owners. Let's go ahead and jump in. Get you a snack, a drink, and let's get ready to listen to what this opinion says. It is 63 pages. I actually think there is an attachment at the end that we won't read, so it may be more like 50 pages. This is coming out of the United States Court of Appeals for the 11th Circuit. Today that I'm recording this is June 8th, 2024. And as you can see at the top of this document, this was filed June 3rd, 2024. So I'm not really that behind this time. And of course, right at the moment when I want to record this is when I need to start having coughing issues, right? All right. We have American Alliance for Equal Rights as the plaintiff appellant versus Fearless Fund Management LLC, Fearless Fund 2GP LLC, Fearless Fund 2LP, and Fearless Foundation Inc. So those were the defendants. This is being appealed from the United States District Court for the Northern District of Georgia. All right, let's jump into this opinion. We've got this coming before Rosenbaum, Newsom, and Luck. Those were the circuit judges. All right, writing for the court. In this appeal from the denial of a preliminary injunction, we are asked to decide whether the Fearless Strivers Grant Contest, an entrepreneurship funding competition open only to businesses owned by Black women, violates 42 U.S.C. Section 1981, which prohibits private parties from discriminating on the basis of race when making or enforcing contracts. We must also decide as a threshold matter whether the plaintiff, the American Alliance for Equal Rights, has standing to challenge the contest. After careful review and with the benefit of oral argument, we hold 1, that the alliance has standing, and 2, that preliminary injunctive relief is appropriate because Fearless's contest is substantially likely to violate Section 1981, is substantially unlikely to enjoy First Amendment protection, and inflicts irreparable injury. We therefore affirm the district court's determination that the alliance has standing to sue, but otherwise reverse its decision and remand with instructions to enter a preliminary injunction. Fearless Fund describes itself as a venture capital fund that invests in women of color-led businesses. Its stated mission is to bridge the gap in venture capital funding for women of color founders, building scalable growth aggressive companies. I think they left out in here. In pursuit of that mission, Fearless supplies grants to businesses under its foundation arm. Fearless makes those grants on the basis of a competitive application process. The Fearless Strivers Grant Contest offers 4 winners $20,000 apiece and digital tools to assist with business growth as well as mentorship. Importantly, for our purposes, the contest is open by its own terms only to Black females who are legal U.S. residents. More importantly, to qualify for the competition, a business must be at least 51% Black woman owned. To select contest winners, Fearless assembles a team of 3 judges who evaluate eligible entries based on the viability and strength of the business, how the business intends to use the grant, and potential for business growth. The judges assign scores for each category, and the entry with the highest composite score wins. The tiebreaker is potential for business growth. If a tie persists, Fearless will bring in a tie-breaking judge to apply the same judging criteria. Because Fearless's contest has been challenged here under 42 U.S.C. Section 1981, which prohibits race discrimination in the making and enforcement of contracts, whether the contest constitutes a contract is central to this dispute. Originally, the contest rules expressly warned applicants in all caps, by entering this contest, you agree to these official rules. which are a contract. The rules provided that the contest winner would receive $20,000 and other tangible benefits. The rules then went on to explain that in exchange, Fearless would obtain the right to discuss or otherwise disclose the ideas in the contestant's entry or otherwise use those ideas without any additional compensation, as well as the right to use the contestant's name, image, and likeness for public relations, advertising, promotional purposes, and in other media, and that the contestant would release and indemnify Fearless for various liabilities and agree to forego litigation in favor of arbitrating any and all disputes. Shortly after the alliance brought suit, Fearless made changes to the contest rules. Most conspicuously, the rules were amended to eliminate the acknowledgement that they constituted a contract. The new rules also vested the foundation with sole discretion to void and disqualify entries that undermine its philanthropic agenda, such as those that espouse any particular political agenda or message, or communicate messages inconsistent with the positive images with which the foundation wishes to associate. Although the amended rules tweaked the obligations and benefits exchanged by Fearless and winners, the contest's basic outline remained the same. An entrant still had the chance to win $20,000 and obtain benefits in exchange for its submission. It still had to give Fearless permission to use its submission, and it still had to waive various claims that it might have against Fearless. Fearless planned to run the contest four successive times. Each entry period lasted a month, at the end of which Fearless would select a winner and, within several days, present the award. The American Alliance for Equal Rights is a Section 501(c)(3) membership organization that, according to its founder, is dedicated to ending racial classifications and racial preferences in America. In this case, the alliance represents several members identified in this lawsuit as owners A, B, and C, all of whom operate their own businesses and wish to participate in Fearless's contest, but are not Black women. The alliance sued Fearless the day after applications opened for the fourth entry period, challenging the contest under 42 U.S.C. Section 1981. In particular, the alliance contended 1. That Fearless's contest constitutes a contract for Section 1981 purposes because entrants enter into a bargained for exchange with Fearless when they apply, and 2. That the contest violates Section 1981 because, by its term, it categorically excludes non-Black applicants from eligibility because of their race. The alliance sought a preliminary injunction to prevent Fearless from closing the application process. As relevant here, Fearless opposed Alliance's request on 3 grounds. First, Fearless asserted that the alliance lacked standing to sue because the individuals it purported to represent, owners A, B, and C, were proceeding pseudonymously and hadn't adequately alleged that each member suffered a concrete or particularized injury. Second, Fearless argued that Section 1981 didn't apply, both because the contest isn't a contract and because it constitutes a valid remedial program. Finally, Fearless argued that even if Section 1981 applied to the contest, the First Amendment protects it. Fearless separately contended that the alliance couldn't show that it had suffered irreparable harm of the sort sufficient to justify injunctive relief. The district court refused to enter the requested injunction. It concluded that the alliance had standing to sue, and on the merits, it agreed with the alliance's contentions that Section 1981 applied to Fearless's contest, and that the contest didn't qualify for any remedial program exception. But the court thought that the First Amendment may bar the alliance's Section 1981 claim on the ground that the contest constitutes expressive conduct, and it therefore concluded that the alliance hadn't shown a substantial likelihood of success on the merits. The district court separately concluded that the alliance hadn't demonstrated that it would suffer irreparable injury, seemingly, or at least in part, because the court thought that Section 1981 does not authorize injunctive relief. This is the alliance's appeal. Number 2, we begin with alliances standing to sue. According to the Supreme Court, standing doctrine is rooted in Article 3 of the Constitution, which authorizes federal courts to hear and decide certain classes of cases and controversies. Any organization may vindicate the rights of its members by suing on their behalf. In order to demonstrate the requisite standing to do so, an organizational plaintiff, like the alliance, must show A, its members would otherwise have standing to sue in their own right, B, the interests it seeks to protect are germane to the organization's purpose, and C, neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit. There's no question here that the alliance satisfies the second and third prerequisites. It seeks racial equality for its members, an interest germane to its purpose, and neither the civil rights claim it asserts nor the preliminary injunction it seeks necessitates individual proof or requires the individual members' participation. The alliance's standing thus turns entirely on whether its members would have standing to sue on their own. To determine whether any alliance member has standing to sue in her own right, we ask, of course, whether she has 1, suffered an injury in fact that is both fairly traceable to Fearless's conduct, and 3, redressable by the requested injunction. Okay, 1, 2, and 3, just making sure I got that. To qualify for injury in fact status, a plaintiff's injury must be A, concrete and particularized, and B, actual or imminent, not conjectural or hypothetical. There's no doubt that the alliance members' alleged injury, exclusion from the contest, is traceable to Fearless's conduct, denying entry to non-Black applicants, and would be redressed by the injunction they seek, requiring Fearless to open the competition to non-Black entrants. The second and third prongs, therefore, are satisfied. The standing question here turns on whether the alliance adequately demonstrated that its members suffered the requisite injury in fact. Generally, when a plaintiff requests prospective relief, we evaluate whether she has sufficiently demonstrated an intent to take the action that she asserts is prohibited. If the plaintiff can show that she is able and ready to do so, she has demonstrated a concrete injury. To be clear, though, the plaintiff must do more than baldly assert that she is able and ready. She must also come forward with some supporting facts, indicating a likelihood that she will actually take the prescribed action. B, Fearless challenges the alliance's standing on 2 grounds, both of which the district court rejected. First, Fearless contends that the alliance can't establish standing because it has identified its members only by pseudonyms. Second, Fearless argues that the alliance hasn't demonstrated that its members are able and ready to enter the contest should Fearless open it to non-Black applicants. We agree with the district court that the alliance has standing to sue. In Summers v. Earth Island Institute, the Supreme Court observed that in order to establish standing, an organization suing on behalf of its members must make specific allegations establishing that at least one identified member had suffered or would suffer harm. Similarly, in Georgia Republican Party versus SEC, we held that an organization lacked standing because it had failed to identify any affected members. Based on those statements, Fearless urges us to embrace a hard and fast constitutional requirement that an organizational plaintiff identify the members it represents by name. And the argument goes because the alliance has identified its members only by pseudonyms, owner A, owner B, and owner C, it lacks standing. Fearless has overread Summers and Georgia Republican Party. Neither decision purported to impose a naming requirement simply by using the term identify. Indeed, neither case had anything to do with anonymity or pseudonymity. In Summers, the Supreme Court held that an organization couldn't demonstrate standing simply by showing a statistical probability that some of its members would incur a concrete injury, without pointing to a member or members who had, in fact, suffered an injury. The court clarified, though, that an organization need only make specific allegations based on specific facts that one or more of its members would be directly affected. Likewise, in Georgia Republican Party, we held that the party lacked standing because it hadn't pointed to any particular member who had or will have suffered harm as a result of the challenged rule. Neither decision, it should be clear, imposed a requirement that an organizational plaintiff identify affected members by their legal names. In fact, the available precedent is to the contrary. Most notably, in Doe v. Stenser, we specifically declined to require an organizational plaintiff to identify by name the members on whose behalf it was suing. And more generally, we have routinely permitted organizations to sue on behalf of pseudonymously identified members. Unsurprisingly to us, in cases addressing arguments materially identical to those here, at least two of our sister circuits have likewise held that pseudonymity poses no bar to a plaintiff's standing. And as a first principles matter, that just makes sense. Fearless has offered no persuasive reason to think that the United States Constitution concerns itself with the particular name by which a litigant is called. Accordingly, the alliance's identification of its affected members by the pseudonyms owner A, owner B, and owner C poses no bar to its standing to sue. 2. Fearless separately asserts that the alliance has failed to demonstrate that owners A, B, and C are able and ready to enter the contest. For support, Fearless principally relies on the Supreme Court's decision in Carney and in Aaron, both we think are readily distinguishable. The plaintiff in Carney brought a First Amendment challenge to a state statute that effectively prohibited non-major party members from serving as judges. The Supreme Court held that the plaintiff lacked standing because he had alleged only and vaguely that he would apply to be a judge, but had never demonstrated that he was able and ready to do so. He identified no anticipated time frame in which he might apply, nor did he point to any prior judgeship applications, nor for that matter did he know whether there would be any upcoming openings during the next cycle, and he made no efforts to determine whether there would be. Similarly, the plaintiff in Aaron wanted to open a methadone clinic, but we held that its alleged injury was speculative because although the complaint alleged that the plaintiff aspired to open a methadone clinic someday, it offered no facts suggesting that the someday was imminent or that the plaintiff had any concrete plan in place for bringing its clinic into operation. The allegations here are different. The complaint and the owner's accompanying declarations go well beyond a boilerplate able and ready recitation. Together, they, one, assert that each owner is prepared to enter the contest, but is ineligible because she is not a Black woman. 2, describe the size of each owner's business. 3, explain that each owner has met the contest's non-race related prerequisites. 4, specify how each owner would use the $20,000 prize if selected. Owner A for improvement and expansion, owner B for website development and marketing, and owner 3 to grow her online presence in order to expand awareness. And 5, pinpoint when the owners would apply if permitted to participate, namely in the fourth promotion period. Those allegations, we think, are more than sufficient by affirming that she is ready and able to apply for a grant in a specific and identified time frame. Each owner demonstrates that she would compete in Fearless's contest, but for its race exclusionary rules. In fact, it's not clear what more the Alliance and its members should have done, short of actually entering the competition and prompting a certain rejection. Article 3 doesn't require so futile a gesture. Before moving on, one word in response to our dissenting colleagues' repeated accusation that the Alliance's members here are flopping, i.e., disingenuously faking injuries for their own strategic advantage. Let us not forget, we're talking about real live flesh and bone individuals who were excluded from the opportunity to compete in Fearless's contest solely on account of the color of their skin. Respectfully, victims of race discrimination, whether white, black, or brown, are not floppers. In sum, because the Alliance has suffered identified members who are in fact able in sum, because the Alliance has sufficiently identified members who are in fact able and ready to enter Fearless's contest, it has Article 3 standing to challenge the contest's exclusion of non-Black applicants. 3. On then to the merits. We consider 4 factors when determining the propriety of preliminary injunctive relief. 1, whether the plaintiff has a substantial likelihood of success on the merits of its claim. 2, whether the plaintiff will suffer irreparable harm in the absence of relief. 3, the balance of the equities. And 4, the public interest. Likelihood of success on the merits is generally the most important of the 4 factors. Accordingly, we begin with the questions whether Fearless's contest violated Section 1981, and if so, whether it fits within any exception to 1981's prohibition or whether the contest enjoys First Amendment protection. A. First up, does Section 1981 cover Fearless's contest? In relevant part, Section 1981 provides that all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, as is enjoyed by white citizens. The statute thereby prohibits intentional race discrimination in the making and enforcement of public and private contracts. Fearless asserts, as an initial matter, that its contest is not a contract within the meaning of Section 1981's guarantee. The district court rejected Fearless's argument and concluded that the contest is indeed a contract. We agree. In seeking to avoid Section 1981's reach, Fearless faces an uphill battle. Recall, for starters, that Fearless's original contest rules warned applicants in no uncertain terms that by entering this contest, you agreed to these official rules, which are a contract. Of course, as already explained, shortly after the Alliance sued, Fearless conspicuously amended its rules to drop the contract designation and to adjust the precise benefits and obligations exchanged by the parties. But the rose remained a rose. It is literally Hornbook law that a contract is an agreement to do or refrain from doing a particular thing upon sufficient consideration. That definition that Fearless's contest fits Fearless's contest to a T under both the original and the amended, i.e., post-suit rules. A winning entrant obtains $20,000 and valuable mentorship, and in return grants Fearless permission to use its idea, name, image, and likeness for promotional purposes, and agrees to indemnify Fearless to arbitrate any disputes that might arise. By any measure, that is a bargain for exchange supported by good and sufficient consideration. It is, in other words, a contract. On appeal, Fearless seeks to recast its contest as nothing more than a vehicle for conveying discretionary gifts that confer no enforceable rights on contest entrants. We don't think so. As already explained, the contest ends in the formation of a contractual relationship between Fearless and the winner. It's no answer to say that the contract itself merely facilitates the making of an eventual contract. The Supreme Court has made clear that Section 1981 protects the would be contractors, here, the contestants, to the same extent that it protects contracting parties. The contest is exactly what Fearless originally acknowledged it is, a contract. Accordingly, by its express terms, Section 1981 applies. B. Fearless next argues that even if its contest is a contract within the meaning of Section 1981, it qualifies under a judge made exception applicable to what Fearless calls valid remedial programs. Like the district court, we disagree. The Supreme Court initially devised the remedial program exception to Title VII's, making sure I have my numbers there right, anti-discrimination provision in United Steelworkers of America, AFL-CIO, CLC versus Weber, and it articulated a test to evaluate such programs several years later in Johnson v. Transportation Agency. A private, race conscious remedial program, the court said, is valid if it, one, addresses manifest racial imbalances, and two, doesn't unnecessarily trammel the rights of others or create an absolute bar to the advancement of other employees. Because Title VII and Section 1981 claims are often brought together in the employment context, we have since extended the remedial program exception to employment discrimination cases arising under Section 1981. Without deciding the issue, we'll simply assume for purposes of this case that the remedial program exception applies to Section 1981 cases, like this one, that arise outside the employment context. Even so, Fearless's contest flunks the Johnson test because it unquestionably creates an absolute bar to the advancement of non-Black business owners. By its terms, the contest is open only to Black females and thus categorically bars non-Black applicants. Fearless's lone response seems to be that the contest doesn't absolutely bar non-Black entrants because they can seek funding from other sources. With respect, that's no response at all. It's tantamount to an argument that as long as there are prospective funders out there who aren't discriminating on the basis of race, Fearless may continue to do so. Not only is that position anathema to the principles that underlie all anti-discrimination provisions, it would, so far as we can tell, render Johnson's absolute bar caveat a nullity. C. Up to this point, we have agreed with the district court's assessment. The alliance has standing to sue. Fearless's contest constitutes a contract within the meaning of Section 1981, and the contest erects an absolute bar to non-Black applicants and thus fails to qualify for any remedial program exception that might apply. The district court, though, ultimately concluded that the alliance wasn't substantially likely to succeed on the merits of its claim because, the court said, the First Amendment may protect Fearless's contest as a form of expressive conduct. For reasons we'll explain, we disagree with that conclusion. The First Amendment, of course, broadly prohibits the government from abridging a private party's freedom of speech. And the Supreme Court has extended the First Amendment's reach to protect even so-called expressive conduct. But, and it's a big but, which effectively controls our analysis here, the Supreme Court has clearly held that the First Amendment does not protect the very act of discriminating on the basis of race. Like this case, Runyon v. McCrary, involved a collision between Section 1981's prohibition on race discrimination in contracting and an alleged First Amendment right. There, Black children alleged that private schools had violated Section 1981 by denying them admission on account of their race. As relevant here, the schools defended on the ground that the First Amendment protected their right to associate with those of their choosing. In rejecting the school's defense, the Supreme Court reaffirmed that the First Amendment guarantees a right to engage in association for the advancement of beliefs and ideas, but denied that it is extended to the act of discriminating on the basis of race. In particular, the court assumed that parents have a First Amendment right to send their children to educational institutions that promote the belief that racial segregation is desirable and that children have an equal right to attend such institutions. But in words with particular resonance here, the court emphasized that it does not follow that the practice of excluding racial minorities from such institutions is also protected by the same principle. The court reiterated that the Constitution places no value on discrimination, and while invidious private discrimination may be characterized as a form of exercising freedom of association protected by the First Amendment, it has never been accorded affirmative constitutional protections. Since deciding Runyon, the Supreme Court has continued to recognize and enforce the critical distinction between advocating race discrimination and practicing it. In RAV v. City of St. Paul, for instance, the court emphasized that where the government does not target conduct on the basis of its expressive content, acts are not shielded from regulation merely because they express a discriminatory idea or philosophy. Notably, the court cited as examples of lawful regulation of such acts both Title VII's prohibition against employment discrimination and Section 1981's prohibition on race discrimination in contracting. So, too, in Wisconsin v. Mitchell, the court cited Runyon as an example of a case in which it had previously upheld against constitutional challenge both federal and state anti-discrimination laws and reiterated RAV's invocation of Title VII and Section 1981 as examples of permissible content-neutral regulations of conduct. The district court noted in Runyon, but found it difficult to square with the court's intervening decision in 303 Creative LLC versus Salinas, which held that a website designer couldn't be compelled to create material celebrating a same-sex wedding. Because the district court deemed Runyon not to be precisely on point, and considering the recency of the 303 decision, it felt compelled to apply the latter rather than the former. With respect, the district court missed the critical distinction between the two decisions, namely the distinction, as the 303 Creative Court described it, between status and message. 303 Creative doesn't recognize and, in fact, expressly disclaims a right to refuse to serve members of a protected class. While the Supreme Court there recognized the web designer's First Amendment right to refuse to express messages with which she disagreed, it clarified that she didn't even claim a right to refuse to serve gay and lesbian customers. There's a lot there. To be sure, the line between pure speech that arguably entails discriminatory sentiments and the very act of discrimination itself may at times be hard to draw. And to be sure, Fearless characterizes its contest as reflecting its commitment to the Black woman-owned business community. The fact remains, though, that Fearless simply and flatly refuses to entertain applications from business owners who aren't Black females. If that refusal were deemed sufficiently expressive to warrant protection under the Free Speech Clause, then so would every act of racial discrimination, no matter at whom it was directed. And on Fearless's theory, the more blatant and rampant the discrimination, the clearer the message. To take just one particularly offensive example, surely a business owner who summarily fires all his Black employees while retaining all the white ones has at the very least telegraphed his perspective on racial equality. For better or worse, the First Amendment protects the owner's right to harbor bigoted views, but it does not protect his mass firing. Fearless's position that the First Amendment protects a similarly categorical race-based exclusion risks sowing the seeds of anti-discrimination law's demise. For all these reasons, we hold that it is substantially likely that the Alliance's Section 1981 claim here would overcome a First Amendment defense. Because we think it probable that Fearless Contest 1 constitutes a contract within the meaning of Section 1981, 2 doesn't qualify for any remedial program exception that might apply, and 3 isn't protected by the First Amendment, we hold that the alliance has established a substantial likelihood that it will succeed on the merits of its claim. D, having concluded that the alliance is likely to succeed on the merits of its Section 1981 claim, we turn briefly to the remaining factors to determine whether injunctive relief is appropriate. We conclude that it is. First, contrary to the district court's determination, in the absence of a preliminary injunction, the alliance's members would suffer irreparable injury. As an initial matter, we have described race discrimination as subtle, pervasive, and essentially irremediable. Moreover, and more specifically, each lost opportunity to enter Fearless's contest works an irreparable injury because it prevents the alliance's members from competing at all, not just for the $20,000 cash prize, but also for Fearless's ongoing mentorship and the ensuing business opportunities that a contest victory might provide. Second, the balance of the equities weighs in the alliance's favor. Although Fearless will presumably need to change its contest rules to bring itself into compliance with Section 1981, that burden pales in comparison to the interest in rooting out race discrimination in all its forms. Finally, the public interest is well served by vindicating Section 1981's terms and aims by ensuring racial equality in contracting. 4. For the foregoing reasons, we affirm the district court's determination that the alliance has the requisite Article 3 standing to sue, but we reverse the court's decision denying the alliance's request for preliminary injunctive relief and remand with instructions to enter a preliminary injunction preventing Fearless from closing its contest. And now we have the dissent. Rosenbaum Circuit Judge dissented. No one doubts the sincerity of an Arsenal soccer player's desire to beat Tottenham, but he can't be allowed to try to win by flopping on the field, faking an injury near Tottenham's goal. For those not in the know, the object of flopping is to manufacture a foul that the player hasn't actually experienced, to manipulate the referee into inappropriately exercising his power to award a penalty kick in the box, where it's likely to result in a goal. Referees' vigilance prevents players who have a sincere desire to defeat their opponents, but who try to do so through manufactured fouls, from commandeering referees to improperly exercise their adjudicatory authority to award unwarranted penalty kicks. Article 3's standing requirement, which comes from the Constitution's limitation on the judiciary to hear only cases and controversies, prevents the legal version of flopping. Among other things, standing seeks to ensure that a party has a genuine and personal stake in the matter, a real alleged injury. That way, the court's decision is not an impermissible advisory opinion, but instead addresses a real need to exercise the power of judicial review in order to protect the interests of the complaining party. As the Supreme Court has explained, the powers of the federal judiciary will be adequate for the great burdens placed upon them only if they are employed prudently, with recognition of the strengths as well as the hazards that go with our kind of representative government. Here, no one doubts the sincerity of American Alliance for Equal Rights' desire to challenge what it views as distinctions and preferences made on the basis of race and ethnicity. American Alliance seeks to do so by challenging the Fearless Foundation's Strivers Grant Contest, designed to help Black women in the business world where they are grossly underrepresented as business owners. But as American Alliance has portrayed its members' alleged injuries, it has shown nothing more than flopping on the field. Although three of American Alliance's members pay lip service to the idea that they are ready and able to participate in Fearless's contest, their declarations show, in context, that none has a genuine interest in actually entering the contest. Indeed, not one has established that she is, in fact, able and ready to enter the contest and would do so in the upcoming period if the contest were open to non Black women. So, American Alliance's alleged injuries don't show a real controversy with real impact on real persons among its membership. Rather, they reflect an attempt to manufacture an injury to allow American Alliance to challenge the contest. That is not enough for standing. The majority opinion does not hold American Alliance to the required able and ready showing. Instead, it incorrectly concludes that American Alliance has established that three of its members have a real and genuine stake in competing in Fearless's contest. So it wrongly holds that we have jurisdiction. We don't. And because we don't have jurisdiction, we lack the power to consider the merits under Article 3, and we must dismiss this matter. Section 1 of this dissent explains the governing law of standing when, as here, a party that seeks to enjoin a program has never applied to participate in that program. Section 2 then recounts American Elite Alliance's allegations and evidence and shows why it fails to establish standing under the governing law. 1. Article 3 of the Constitution limits the judicial power to cases and controversies. For a matter to qualify as justiciable, the plaintiff bears the burden of for a matter to qualify as a justiciable case or controversy, the plaintiff bears the burden of satisfying, among other things, the standing requirement. To establish standing, a plaintiff must show she has experienced or is threatened with an imminent injury in fact. The defendant likely caused or will cause that injury, and a favorable decision can redress that injury. The problem here is that American Alliance has failed to establish an injury in fact, the first and foremost of standing's three elements. To meet the injury in fact requirement, a plaintiff must have a personal stake in the matter. That means that the plaintiff must show that she suffered an invasion of a legally protected interest that is concrete and particularized and actual or imminent, not conjectural or hypothetical. In other words, the plaintiff must have personally suffered some actual or threatened injury, and that injury must be of a certain kind. The Supreme Court has held that a particularized injury is one that affects the plaintiff in a personal and individual way. An undifferentiated alleged injury is not enough. The claimed injury must be distinct to the plaintiff. As for concreteness in claims seeking injunctive relief, a plaintiff must show both intention and specific plans to engage in activity that is likely to expose her to injury. That is, concreteness demands a showing that the plaintiff will suffer a particular injury caused by the action challenged as unlawful. As the Supreme Court has explained, concrete injury removes from the realm of speculation whether there is a real need to exercise the power of judicial review in order to protect the interests of the complaining party. In other words, the alleged injury must be de facto. That is, it must actually exist. Concrete means a real injury. So a mere desire to obtain sweeping relief cannot be accepted as a substitute for compliance with the general rule that the complainant must present facts sufficient to show that her individual need requires the remedy for which she asks. These standards ensure that federal courts decide only the rights of individuals and that federal courts exercise their proper function in a limited and separated government. Indeed, federal courts do not issue advisory opinions. These limitations on the judicial power protect the democratic form of government from the, in large measure, insulated judicial branch. Put simply, Article 3 limits our jurisdiction to resolving only a real controversy with real impact on real persons. No flopping allowed. American Alliance attempts to satisfy the standing requirement through associational standing, through the alleged injuries of three of its members. That means it must show that its members would otherwise have standing to sue in their own right. It hasn't done that. None of American Alliance's members have applied for the Fearless Strivers Grant contest, so they haven't been rejected and can't claim they've already suffered an injury. But that, of course, is not the only way to establish an injury. After all, the contest rules limit eligibility to Black women, and Article 3 doesn't require the futile gesture of applying for a contest for which one is ineligible. American Alliance's members can alternatively satisfy the injury requirement by showing that they are able and ready to apply to the contest and are likely to do so if we invalidate the eligibility requirement. The Supreme Court has not decided whether a statement of intent alone in certain circumstances can ever be enough to show standing. But in Carney, it held that even a clear expression of intent doesn't cut it when the context surrounding that expression calls its credibility into question. I spilled considerable ink discussing the facts and the Supreme Court's legal analysis in Carney because that precedent controls our analysis here. In Carney, lawyer James R. Adams challenged Delaware constitutional provisions governing judicial nominations. Those provisions required judicial appointments to certain Delaware courts to reflect a partisan balance between the two major political parties and precluded individuals unaffiliated with one of those parties from serving on certain courts. As a political independent, Adams complained that Delaware's provisions precluded him from having his judicial application considered. The Supreme Court said that to satisfy standing, Adams had to at least show that he was likely to apply to become a judge in the reasonably foreseeable future if Delaware did not bar him because of political affiliation. And as the court explained, Adams could do this only if he was able and ready to apply. Despite Adams' protestations to the contrary, the court concluded that Adams failed to show he was able and ready to apply. Adams attested that he would apply for any judicial position that he thought he was qualified for, and he believed he was qualified for any position that would come up on any of the courts. He also swore that he would seriously consider and apply for any judicial position for which he feels he is qualified, and that he believed he met the minimum qualifications to apply for any judicial officer position. On their face, the Supreme Court suggested these attestations seemed enough to show that Adams was able and ready to apply. But the Supreme Court cautioned that Adams' statements must be considered in the context of the record, and that in turn contained evidence showing that at the time he brought this lawsuit, Adams was not able and ready to apply. To support its conclusion, the court noted that Adams had not applied for previous positions, had recently changed his party affiliation after reading a law review article suggesting the unconstitutionality of the Delaware constitutional provisions at issue, and telling the author that he'd like to pursue this, and had taken no action to indicate that he was able and ready to apply for judgeship, among other record evidence. In the Supreme Court's view, this context smothered Adams' representations that he was able and ready to apply for a judgeship. The court reached this conclusion even though Adams offered explanations for the contextual evidence on which the Supreme Court relied in finding that Adams had failed to show he was able and ready. Adams said, for instance, that he failed to apply for a judgeship earlier because he wasn't interested at that time, and he changed his party affiliation to reflect his progressive views. And he argued the lack of other evidence proved little or nothing about his intentions. The Supreme Court was not persuaded. To be sure, the court recognized that Adams's words indicated that he was able and ready, but the court observed that the context offered Adams no support for his words. Rather, the court concluded, the context reflected only a mere desire to vindicate Adams's view of the law, not an actual desire to become a judge. Under these circumstances, the court warned that finding Adams had satisfied the injury requirement would significantly weaken the long-standing legal doctrine, preventing the court from providing advisory opinions. The problem, the court said, was that Adams had not sufficiently differentiated himself from a general population of individuals affected in the abstract by the legal provision he attacked. At bottom, injury in fact requires an intent that is concrete. In other cases, the Supreme Court has also required contextual facts, showing that a plaintiff is likely to apply to the challenge program in other cases. In Adirondack Constructors, Inc., v. Pena, a subcontractor challenged a race-based program for allocating contracts. Based on the context there, the Supreme Court determined that the subcontractor had made an adequate showing that sometime in the relatively near future it would bid on another government contract that offered financial incentives to a prime contractor for hiring disadvantaged subcontractors. In reaching this conclusion, the court found it relevant that the company bid on every guardrail project in Colorado. Nothing in the record suggested that would change, and the company often had to compete against others who qualified for the advantage. In a Northeastern Florida chapter of Associated General Contractors of America versus City of Jacksonville, the Supreme Court reached the same conclusion for similar reasons. There, an association of contractors challenged the constitutionality of an ordinance that gave preferential treatment in awarding city contracts to certain minority owned businesses. The court noted that the association alleged, and the city did not contest, that its members regularly bid on construction contracts with the city and that they would have bid on contracts set aside pursuant to the city's ordinance were they so able. In other words, the association showed it was in fact able and ready to apply for city contracts if the court declared the ordinance invalid. As a result, the court concluded the association had shown cognizable injury and had standing. Gratz v. Bollinger provides yet another example of how a plaintiff can show eminent, concrete, and particularized injury when the challenged program requires an application. There, a plaintiff sought admission at the University of Michigan. He was denied. The complaint alleged he would transfer to the university if offered an opportunity and intended to apply to transfer if the admissions system changed. Among other relief, he sought an order requiring the program to offer him admission as a transfer student. The Supreme Court determined that the plaintiff had sufficiently shown he was able and ready to apply for transfer if the court invalidated the university challenged admissions practice. It reached this conclusion based on the plaintiff's prior application for admission. The fact that an underrepresented minority applicant with his qualifications would have been admitted under the university system, and the fact that the university had a rolling transfer program open for application each year. As the Supreme Court deserved in Carney, in all these cases where it found the plaintiffs were ready and able to apply, each plaintiff introduced at least some evidence that they had applied in the past. There were regular opportunities available with relevant frequency, and they were able and ready to apply for them. But in Carney, when Adams merely said he would apply, but the record evidence failed to support that contention, the Supreme Court determined that Adams lacked an actual desire to become judge, so he had not shown he was in fact able and ready to seek a judgeship. We have also found we lacked jurisdiction when a plaintiff failed to allege facts supporting the plaintiff's bare claim that it had intended to do something in the future. In Aaron, the plaintiff company challenged a state law that interfered with its ability to open a clinic. The plaintiff's complaint alleged that it planned to open a clinic and included details on the technologies it would use and the medical conditions it would treat. Even so, we held the plaintiff offered no facts that it had any concrete plan in place for bringing its clinic into operation. We emphasize that the plaintiff failed to allege it had taken any concrete steps, like selecting a location for the clinic, securing a lease option, making progress towards government approvals, or interacting with potential clients. Even more on point, the Second Circuit recently considered associational standing and applied Carney in a case quite similar to ours. In Do No Harm v. Pfizer, the organization Do No Harm sued Pfizer, alleging that one of its fellowship programs that seeks to advance students and early career colleagues of Black/African American, Latino/Hispanic, and Native American descent unlawfully excludes white and Asian American applicants. Do No Harm sought to establish associational standing. It alleged that it had at least two members who were ready and able to apply for the 2023 class if Pfizer eliminated its alleged discriminatory criteria. In support, Do No Harm submitted declarations from members A and B. Each member averred that he or she met all the eligibility requirements set by Pfizer, including that they were undergraduate juniors, maintained GPAs of 3.0 or higher, and were involved in campus life and held leadership positions in various campus activities. Both members attested that they were able and ready to apply to the 2023 class of the fellowship if Pfizer removed the allegedly discriminatory race requirement. The second court affirmed dismissal of the case, holding that Do No Harm failed to establish standing. In relevant part, in a separate concurrence, Judge Wesley concluded that members A and B did not prove they suffered actual or imminent injuries. Rather, Judge Wesley noted that the only standing evidence Do No Harm submitted were virtually identical declarations about member A and member B's intentions to apply for Pfizer's fellowship. But those declarations were insufficient because they were vague and conclusory. Though they address the ability prong of the able and ready requirement, the declarations offered very little on the readiness prong. They said only that the members would like to apply, weren't interested in applying, because it was a prestigious program and it seems like a great professional development opportunity. Were drawn by the fact that Pfizer would pay a full scholarship for an MBA program and were able and ready to apply to the 2023 class and were prepared to meet the program's requirements and expectations if accepted. Judge Wesley explained that, even read liberally, these are a few words of general intent which do not suffice to prove readiness. As Judge Wesley reasoned, members A and B described no concrete plans for applying to the fellowship if it stopped discriminating against them tomorrow. For instance, they never indicated whether they prepared any materials to submit to the fellowship, whether they asked Pfizer for more specifics about the program or talked to any Pfizer employees, or whether they adjusted their studies to strengthen their candidacies, perhaps by taking courses in biotechnology or business administration. Based on this context and applying Carney, Judge Wesley explained that members A and B had failed to signal a concrete readiness to apply to the fellowship. So Judge Wesley said members A and B did not establish an injury in fact and thus standing. 2. Owners A, B, and C, on whom American Alliance hangs its bid for standing, fare no better than Adams, Do No Harm members A and B, and Aaron Private Clinic Management, all of whom failed to establish standing. This matter is not like Adirondack Constructors or Northeastern Florida chapter, where the plaintiffs had a history of bidding on the types of contracts at issue, showing the genuineness of their claim that they would bid on future contracts. Instead, it's like Carney, Aaron, and Do No Harm. In all these matters, like the matter before us now, the plaintiffs failed to show they had concrete plans to engage in the relevant conduct, even if they could do so. True, owners A, B, and C each profess to be ready and able to apply for a grant through the contest in the fourth promotion period. But those words aren't enough because the surrounding context tells another story. Like the situation with Adams and Do No Harm members A and B, the context here betrays owners A, B, and C's lack of an actual desire to enter the contest. At least 6 circumstances belay the owner's professions that they are ready and able. First, the majority opinion contends that the declarations show that each owner would compete in the contest if they could. But in fact, not a single declaration actually says that. The declarations don't say that any of the owners would enter the contest, or plans to enter the contest, or intends to enter the contest, or is even thinking about entering the contest. Rather, each says simply that the owner is ready and able to apply for a grant for business A, B, or C through the Fearless Strivers Grant Contest in the fourth promotion period, but she is ineligible because she is not a Black woman. Even Adams said more. He at least said he would apply. None of the owners have said as much. Second, each declaration is precisely 15 paragraphs long and is almost exactly the same. The only differences between the declarations appear in each owner's state of location and the vaguest descriptions of what each owner says she would do with the money. Business A would use the $20,000 grant for improvement and expansion of the business. Other than that, the declaration's only substantive statements purport to show in the most generic way possible that the owners meet the contest's eligibility requirements, except that they are not Black. These cookie cutter business A, B, or C had an annual revenue of more than 50,000, but less than 3 million in 2022. Okay, I probably could have skipped that. These cookie cutter declarations are even more threadbare and devoid of substance than the near carbon copy ones at issue in Do No Harm. Third, not a single owner attests that she has ever sought a grant of any other kind or entered a similar contest for her business in any other circumstances. So while the owners need not have applied for the contest here to show they have a personal stake in entering it, they've established no past interest of any type in business grants of the sort that Fearless awards, regardless of eligibility criteria. In this way, they are like Adams, who never applied for a judgeship, and members A and B who did not indicate that they had previously applied for a fellowship type program of any kind. They are unlike the plaintiffs in Adirondack Constructors or Northeastern Florida chapter, who supported their statements of intent by showing that they had historically and regularly applied for the same kinds of bids as the ones at issue. Fourth, the declarations otherwise betray the owner's lack of an actual desire. The contest rules expressly state that Fearless will judge entries based on 1, viability and strength of business, 2, how the business intends to use the grant, and 3, potential for business growth. And if there's a tie, the tied entries will be rejudged based on potential for business growth. Given that these are the public criteria on which Fearless would judge the owners if they actually entered the contest, what do the owners' declarations say about these things? Absolutely nothing. None so much as mention viability and strength of business or potential for business growth. We don't even know what kinds of businesses these are, how long they've been operating, or any other facts that would be relevant to assuring ourselves these are operating businesses, let alone ones that genuinely desire to enter the contest. And as I've noted, the owners could not be vaguer about how they would use the grant if they won. To be sure, to establish standing, a plaintiff need not show she would be successful in the contest if she were eligible. But the declaration's utter lack of relevant information, other than the owners meet the other eligibility criteria, like the surface level declarations of members A and B and Do No Harm, shows the owners haven't even really considered entering the contest. Indeed, it unmasks the owner's lack of an actual desire. Fifth, paragraph 13 of each declaration professes both I and business A, B, or C became members of American Alliance for Equal Rights because we support its mission as well as this lawsuit. So, although the record contains no indication that they've applied for or even been interested in any grants in the past, owners A, B, and C apparently decided to join American Alliance so they could sue Fearless to enter Fearless's contest. This circumstance echoes that of Adams's contact with the law review article's author, advising the author that he just read the author's law review article and would like to pursue this, with the author responding by suggesting several attorneys who might handle the matter. And six, American Alliance's president's declaration only further confirms what the owners' declarations betray. The owners have no real interest in or intention of, in fact, entering the contest. For starters, American Alliance's president, Edward Bloom, attests that the organization has at least two members who are ready and able to apply to the contest, but cannot because they are the wrong race. And it says this even though the declaration also avers that Bloom has spoken with owners A, B, and C and has discussed businesses A, B, and C with them. So, which of the three owners are the two he asserts are ready and able? Or more to the point, which is the one who, by Bloom's implicit admission, is not? As I've noted, all three of the owners' declarations say essentially the same thing. So the fact that at least one of the three is not ready and able undermines the likelihood that the other two, in fact, are. Not only that, but as I've mentioned, Bloom's declaration asserts only that he has spoken with owners A, B, and C and has discussed businesses A, B, and C with them. It says nothing more about any of the businesses or owners, not to mention anything that might show the owners had a genuine interest in participating in the contest. Bloom's affidavit also reflects that he has financed other race-based challenges involving other organizations and programs. In particular, he mentions Fisher v. University of Texas at Austin and Fisher v. University of Texas at Austin, a different case. He's also sponsored litigation making race-based challenges in Shelby County v. Holder, Students for Fair Admission versus Harvard and University of North Carolina, and others. There's certainly nothing wrong with bringing multiple lawsuits on behalf of allegedly injured parties. Rather, it could reflect a sincere and deeply committed desire to vindicate what one perceives to be a general interest on behalf of the public. The problem for Bloom and America Alliance, though, is that such a desire is not enough to establish a cognizable injury in fact. So just as the context in Carney and Do No Harm revealed that Adams and Do No Harm members A and B, respectively, did not genuinely seek to apply for a judgeship or fellowship, despite their assertions that they were able and ready, the contextual evidence here establishes that owners A, B, and C, and by extension, American Alliance, are not able and ready to enter the contest, even though they attest that they are. The majority opinion offers no answer to the utter dearth of contextual support for the owner's naked assertions that they are ready and able to apply. It can't. There's no good answer that can successfully navigate precedent. At bottom, American Alliance and its members have shown nothing more than flopping on the field when it comes to establishing an injury in fact. For that reason, they have failed to satisfy standing, and we lack jurisdiction. In short, this is not a genuine live dispute, and we have no business deciding it. 3, I would dismiss this matter for lack of jurisdiction. I respectfully dissent from the panel's decision to the contrary. And that, my friends, is the case. Of course, there's Appendix A here where you can go back and read the declarations. And I'll do that in a separate video. So that sort of sums everything up. So let me know your thoughts. Do you think that they met the standard? Do you think that there was standing, that owners A, B, and C, based on what we heard so far with those original cases that were discussed, based on that, based on what the majority stated and what the dissent stated, do you think this case should have been decided the way it was? All right. Okay. Wait. I'm going to go ahead and look at these declarations that they submitted because I think it fits better to just go ahead and include it. We read the majority opinion. We just went through the dissent. Let's look at them now. And so I don't know why I was thinking that that needed to be something different, because it definitely does not. It definitely needs to be included here. So here's Appendix A. And this is the declaration of owner A. Okay, so the first part, owner 18. I'm primary and sole business owner of business A. And it says here, I'm ready and able. I would use the grant for improvement and expansion of the business. I meet all the requirements. I'm a woman. I live in New York. I'm above the age of majority. I mean, yeah, I'm a limited liability company and I have annual revenue of more than 50,000. Not a part of Fearless Fund. I became a part of American Alliance because I support its mission. I'm signing this declaration under penalty of perjury. And then there's the signature. Then here's declaration of owner B. Yeah, you see pretty much the same thing. It says this person would just use it for website development and marketing. They're located in Virginia. Yeah, same sort of thing here. And then we get to C, and C says same thing. And then we get to 3 where it says I'm ready and able, and they talk about not eligible. They have the 20,000. I was trying to see what they were saying they were going to do. Okay. Yeah. A little bit different. A little bit different. So there you have it. There they are. And then his declaration about the association there. So that's pretty much it. That gives you an idea of, what they were basically saying was different about these. Let me pull myself back on the big screen here. So let me know in the comments your thoughts as we sort of go through that and understand what was going on there. And I may go back and look at some of the original filings when it was in the lower court. But let me know your thoughts. All right. Don't forget to like the video and subscribe. Peace.